Hello everyone, you are welcome to Anchor Network where you get reliable and authentic news that are so crucial to you. I say big thank you to everyone who has been part of this channel and who has taken time to subscribe. And if you are yet to subscribe, I say please click the red subscribe button and also the bell icon. The bell icon will allow you to get notified anytime we publish any news.
So that the Biafrans agitating for their independence can be granted self-autonomy, just like people in the West can be granted self-autonomy. All the regions, fortunately, we now have 6 geopolitical regions. Each region should now be structured or empowered to govern itself as an autonomous region within Nigeria, and every person will be happy. So we made the court understand this, that we are not destroying the sovereignty. We're not fighting against the sovereignty of Nigeria. We're not destroying Nigeria. We just want to be free to govern ourselves.
All right, okay. There is one other thing that came up with the issue of identity. The issue of the identity of Biafran people. What is your position on that of the court?
Yeah, we also raised it before the court that the first and second defendants, that's the federal government and Attorney General, they sent their policemen and security officers to harass our members, harass the Biafrans who put on their T-shirt or put on any insignia that's written Biafra, that it is wrong. Then the judge wanted to know more, and then we explained to the court that indigenous identity of a person is different from his nationality or citizenship. That all of us are Nigerian citizens, but that the law says that we have the right to maintain our indigenous identity. And we gave him examples with Britain, where we have the Scots, the Scotland, people of Scotland, that's Scots, and they maintain their indigenous identity. The Irish people maintain their indigenous identity. The Welsh, all of them maintain their indigenous identity, but they are still all British. So we can all be Nigerians with our indigenous identities. And the Biafrans want they maintain their indigenous identity as Biafrans without destroying or opposing the sovereignty of Nigeria. That is simple, and the judge understood what we're saying.
One last thing.
The real IPOB is not a terrorist organization, says Federal High Court. IPOB customary government, which is different from the IPOB of Nnamdi Kanu, sued the federal government of Nigeria through their attorney barrister Emeka Adolf Chigozie Emekesiri. Here is a report of their first court outing of October 2nd, 2019. Justice Buba of Federal High Court, Enugu, on Wednesday clarified that the indigenous people of Biafra, IPOB, under the customary government is not a terrorist organization, as it is not the same as the one prescribed by the federal government. He made this clarification when the matter between customary governments of the indigenous people of Biafra, customary government, IPOB, versus the federal government of Nigeria was called up in the court today. The counsel to the federal government from the Ministry of Justice, Barrister E.E. Nwokolo, had presented an affidavit of fact that IPOB that instituted the case is proscribed and as such should not be heard by the court. In his reaction to the claim, the Solicitor General of the CG IPOB, Barrister Emeka Chigozie Emekesiri, insisted that the IPOB in the suit is under the customary government, answerable to the Supreme Court of Elders. After listening to both parties, Justice Buba of the Federal High Court 1, the admin judge, quashed the affidavit of fact presented by the counsel to the federal government, maintaining that the plaintiff has been able to prove that the IPOB in the suit is not a terrorist organization. The judge reserved ruling on jurisdiction for Friday, October 4th, 2019. The customary government of IPOB had, through an ex parte application filed on June 20th, 2019, sought the court's leave and jurisdiction to commence a suit action against the defendants. Also joined as defendants in the suit, apart from the Attorney General of the Federation, were former heads of state General Olusegun Obasanjo and General Yakubu Gowon for their respective roles during and after the Civil War in 1967. In an originating summons in the lawsuits marked FHC/EN/CS 103/2019. The plaintiff is praying the court to determine whether the direction or instruction given to members of the claimants by President Muhammadu Buhari on March 5th, 2016 on Al Jazeera television that they should organize themselves and vote to have a state within a state, which they have accepted and complied with by organizing themselves, as created an obligation on the defendants from which the defendants can no longer withdraw. The plaintiff's lawyers also asked the court to determine whether, by the direction of instruction of the defendants, which the members of the claimants have accepted and complied with as aforesaid, they now have the right to conduct their referendum and vote to their to have their state of Biafra as a self-governing autonomous region within the Nigerian state, just like Scotland governs itself within the United Kingdom of Great Britain. Whether, notwithstanding and in the absence of any directions, instructions, promises, or offers from the defendants, the members of the claimants have the legal and inalienable right to self-determination pursuant to Articles 19 to 25 of the African Charter on Human and People's Rights, Ratification and Enforcement, Act Cap A9, Laws of the Federation of Nigeria, 2004, Cap 10 LFN 1990. Whether it is an offense and unlawful contrary to any provisions of the Constitution of the Federal Republic of Nigeria 1999 or any other law whatsoever, for the remnants of the Biafrans who survived the war with their descendants to identify themselves as Biafrans by indigenous identity and display their native flags and emblems and Biafra trademarks on their properties and products, as they do now, with remaining loyal to the government of the Federal Republic of Nigeria as Nigerian citizens, and whether it is lawful for the defendants to harass, molest, arrest, and detain members of the claimants for identifying themselves as Biafrans with their native emblems. Whether the amalgamation of the members of the claimants with the peoples of other ethnic nationalities in the south and north by the British government to form one country called Nigeria was with the consent and agreements of the indigenous people of the lands, and if the answer is in the negative, whether the order in Council 1910 to 1913 made by the British government to create Nigeria in 1914 was null and void ab initio for lacking legitimacy, as it could form the basis of the Nigerian constitution, thereby rendering the amalgamation invalid. Whether the Constitution of the Federal Republic of Nigeria 1963, which took effect on 1st of October 1963 and remained in force until the midnight of 30th September 1979, the defendants were right to seize and confiscate the assets, properties, money, and all treasures belonging to members of the claimants by promulgating the Abandoned Properties Act of 28 September 1979, while the 1963 Constitution was in force, being more than 9 years after the war and after the declaration of One Nigeria, while regarding members of the claimants as Nigerian citizens but depriving them of their properties, money and assets, and if the answer is in the negative, whether the defendants are justly justified to withhold the said money, properties, and assets belonging to members of the claimants, whether the defendants were justified to violate the international humanitarian law and the laws of war known as the Geneva Convention 1949, to which the defendants acceded to and ratified on 20th June 1961, by bombing the Biafran civilians, killing the Biafran civilians, and using starvation to kill the children, women, and the elderly of the civilian population of the indigenous people of Biafra in the war of 1967 to 1970 in order to win the war. Whether the right of self-determination provided under the Article 20 of the African Charter or Human Rights and People's Rights, Ratification and Enforcement Act overrides and supersedes the provision of Section 1 and 2 and the Constitution of the Federal Republic of Nigeria 1999, pursuant to the Judicial Authority in the case of IGP versus AMPP 2007, 18, NLWLR, Part 1066, 457 at 500 para BC. Whether it is lawful for the defendant to marginalize, persecute and discriminate against the claimant's region of the southeast and south-south of Nigeria by refusing to develop their region, refusing to revamp their seaport, refusing to dredge their river Niger and other inland rivers to the sea, and threatening to shut down or downgrade their international airports at Enugu. Whether it is lawful for the defendants to acquire a radio license and set up a radio station for the Fulani Esme and pay them or offer to pay them the sum of 100 billion naira without doing the same thing for members of the claimants who are also Nigerian citizens. And if the answer is in the negative or affirmative, whether the defendants act in acquiring the said radio station for the Fulani Esme are paying them or offering to pay them the sum of 100 billion naira without according to the same favor or privilege to members of the claimants being equal citizens of the same country constitutes a violation of section 42 of 1B of the Constitution of the Federal Republic of Nigeria 1999 and therefore unlawful. Also attached in the originating summons is a video record in a flash drive marked as Exhibit BF01, whether the president was captured saying that the claimants should organize themselves and to vote for a state within a state. The plaintiff in the substantive suit is seeking an order of the courts to declare that the direction or instruction or promise given by the President of the Federal Republic of Nigeria, President Muhammadu Buhari, to members of the claimants on the Al Jazeera television on or about the 5th day of March 2016 that they should organize themselves and vote to have a state within a state which they have accepted and complied with by organizing themselves by the defendants constitutes irrevocable promise by the defendants from which they can no longer withdraw. So guys, this is a very long article. You can try to understand the terminology of all these what is it called, terminology of all these lawyers. You need to really listen and try to deduce the whole thing what they are just trying to say, because a lot of quoting, plaintiff, defendants, all this cap, this and that and all of that, case number, you quite understand. But what we are interested is the justice that is needed. And so one thing that is really getting confused, they are talking about IPOB, the customary government, that is different from the Nnamdi Kanu. If it is IPOB, it's IPOB. I don't know what they are talking about, because it's the same thing that IPOB, the Nnamdi Kanu, is saying. These are the things that they were talking about injustice. Those are the things. So there's no difference. I don't even know what they are trying to play. But all I know is that no matter what, justice must be given to them, and which is they've already started getting the justice without even this justice in the first place, without this not prescribing them this as a terrorist group, whether Nnamdi Kanu or whatever other one they are talking about. I would like the Biafrans to be able to tell us the difference between these two things they are talking about, these two IPOB they are talking about, the one of Nnamdi Kanu and the one of the customary government. And like I said, whether it is in Nnamdi or no, none of those group, according to them, should even be prescribed in the first place. Just like I've been asking questions, the same Nnamdi they are talking about is moving here and there in the developed countries, the countries that be. So what are we talking about? So this is part of it. Of course, I'm sure maybe in my own opinion, this other group might be under Nnamdi Kanu. So definitely, if they are trying to segregate it, but what we know is that the Federal High Court has said, they are not supposed to be called or to be prescribed as a terrorist group, and the same demand that they are talking about. So guys, you can shed more light on this. Leave your comments below in the comment section. Thank you very much for always being there. Bye.